Now, two advocacy groups have joined the push for more privacy and the protection of journalists. The Right to Know campaign and Privacy International have applied to be admitted as friends of the court in a case that argues that South Africa's surveillance law, RICA, is unconstitutional. RICA was passed, you'll recall, in 2002. It regulates the interception of communications. Last year, AmaBhungane launched their court case after learning that state intelligence agents had bugged one of their journalists, Sam Sol. The Investigative Unit has argued that RICA gives government unfettered access to private information and that the targets of spying should at least be informed, even if it's later on. Well, to discuss, we're joined by Advocacy Co-ordinator at AmaBhungane, Karabo Rajuili, as she joins us from Seapoint. Thank you for being with us, Karabo. So does this strengthen your case, your hand, Right to Know and Privacy International joining?
Thank you so much.
All right, Karabo, I think there's a delay. Let me try again. Does this strengthen your case that Right to Know and Privacy International are joining you?
Yes, Francis. The application by Right to Know as well as Privacy International strengthens our case in a number of ways. What we've said in our application as AmaBhungane is that our surveillance law, RICA, has got two fundamental weaknesses. First, the safeguards which are necessary for any kind of law to be the kind of law that abides by the Constitution and doesn't become vulnerable to the excesses of power simply aren't there. The second thing that we say in our application is that there is state surveillance which happens completely outside of any kind of legal framework, and this is done by what is called the National Communications Center. What the Right to Know application as well as the Privacy International application to be admitted as amicus do is say that this is not just something which should concern certain categories of individuals like journalists as well as lawyers, which is the subject of our application, because lawyers as well as journalists have to protect their confidential sources, or with lawyers it should be their clients. But actually the importance of having a surveillance law which does protect fundamental freedoms and our Constitution fundamental rights is for everybody, every single person who lives in South Africa. What Privacy International's application does is essentially say globally there's different types of laws which can be applied in a country to ensure that intelligence agencies and others don't use their powers in a way that abuses its people and its citizens. And so Privacy International definitely brings that global perspective to a very real case that we're grappling with here in South Africa.
Where is the legal process? Because you started this action, I think, early last year.
We did. So we officially launched the application in April last year, and we cited a number of respondents in our applications, including the Minister of Justice, a variety of the intelligence agencies, including the State Security Agency, as well as other government departments who have got some kind of role in the surveillance of our communications, so the Minister of Telecommunications and others. The process right now is that we've gone through which is usually quite a long process of ensuring that all of the different respondents, so the Minister of Justice, the various intelligence agencies, have got an opportunity to reply to some of the arguments that we put before them. That process is now coming towards an end, so we've received most of the replying papers from the various respondents, and we should be ready to hopefully get a court date in the coming months.
And like you said, one of your main arguments is that journalists who should protect their sources are themselves vulnerable. Take us back to Sam Sol of AmaBhungane finding out that he was under surveillance.
Yes, so the case which we are using as a basis is Sam Sol being the subject of an interception warrant. What happens often, and what I think the Right to Know case does it very well, is that in many instances journalists discover that they've been the subject of an interception through their sources. So at the time in 2008, 2009, Sam Sol was working on a case related to the eventual dropping of charges against former President Jacob Zuma by the National Director of Prosecutions at the time. And Sam was talking to confidential sources in the process of developing the story. At the time, some sources had come to him to say, you might want to know that your communications are being monitored. But the problem with RICA is that you simply never know lawfully whether or not your communications are being monitored in any kind of way. We were finally able to get concrete evidence of this happening when the DA launched its application to have Zuma's charges reinstated in what is known as a spy tape saga colloquially. And in the replying papers, which Zuma's former attorney Michael Haile submitted, there was an annexure attached to that, which had a transcript of Sam Soul and his source Billy Downer's conversations about the case. And so this was for the first time concrete evidence that some kind of monitoring of his communications had happened, and this allowed us then to launch this application to say, this has happened, we've got actual proof and evidence, and therefore it must be challenged. But I think for journalists it speaks to something more fundamental, and that is the problem of many journalists who are taking on these major corruption cases, having their communications bugged. We know that there's been other journalists at the Mail and Guardian. We know that Jacques Poen, he wrote his book, potentially had his communications surveilled. And so what we are seeing is a trend of, rather than our surveillance law being used in legitimate intelligence gathering, so to protect the general national interest of the country, it's being used against journalists or others who are doing work to hold power accountable.
And what's really difficult for me is that a judge allowed that to happen, because RICA still requires you to go to a judge. How much discretion, because we know a lot of the judges really do err on the sides of freedom of speech, the rights of journalists. How much discretion do they have under the current RICA law when spies come and say we want to surveil, go after a journalist?
So, Francis, this is one of the key areas of our challenge. We say that the RICA judge process itself is vulnerable to applications being made against journalists to have their communications tapped. Now, the RICA judge is a retired judge who's appointed by the Minister of Justice to make sure that when an agency, crime intelligence or state security comes before them, they adjudicate it in a way that upholds the rights of the person who might need their communications to be monitored. We say that this process has got fundamental flaws. Firstly, the judge is relying purely on the evidence which is presented by your crime intelligence officer or your intelligence agencies, and therefore the judge has got no way of knowing whether or not the information which is being presented to them is completely truthful information. We know that there's fundamental weaknesses because in the Sunday Times case where their journalists had their communications bugged, the crime intelligence officer who wanted the warrant from that RICA judge deliberately lied in that application, which shows us that that process itself needs to be reviewed. What we argue for in our case is that there needs to be a public advocate in that process, so somebody who can provide counter arguments for the person's communications who should be communications which are potentially being monitored. And secondly, the RICA judge should also consider other constitutional rights. And so, for example, where the subject of an interception warrant is a journalist, the RICA judge should consider this as part of whether or not to grant that interception warrant. That currently doesn't happen.
What's interesting, President Cyril Ramaphosa reportedly also spied on launching an investigation into those state security agencies. But you're saying that even if we clean up the official side, you still need a better law.
Absolutely. The work to reform the manner in which our intelligence agencies is going to require a multifaceted approach. And so one of the key parts of it is definitely ensuring that the laws themselves have got the necessary safeguards. But then it's also about, I think, correctly reforming the intelligence agencies in the way in which they work. There was a process which some may remember, which was instituted in the early 2000s, and that was around the Matthews Commission report, and this was when, under the Mbeki administration, politicians had their communications tapped. And the Matthews Commission report came with some very, very strong recommendations around the need for much greater oversight over intelligence agencies, including, for example, the Inspector General of Intelligence having much more independence from the State Security Agency, ensuring that the Parliamentary Committee, which oversees the intelligence agencies, operates in a more transparent manner. And so part of it, yes, is going to be law reform, and I think that's a strength of our application, but another part of it is going to be reforming the way in which our intelligence agencies work.
All right, thank you very much. So, Right to Know joining AmaBhungane, really pushing for more checks and balances in the RICA law and saying that journalists should not be left vulnerable to being spied on. That was Advocacy Co-ordinator at AmaBhungane, Karabo Rajuili. We take a short break. We'll be back with more.